So good day everyone. So for today's lecture, we will have module 3. Um, and this module will deal on contracts under the Civil Code of the Philippines. So for a quick background, contract places emphasis on the meeting of the minds between two contracting parties, which takes place when an offer by one party is accepted by the other. And then, contracts have various essential requisites that needs to be complied in order for it to be a valid contract. So, ang iba naman yung contracts nga wala naga-conform sa mga essential requisites nga kinahanglan is called defective contracts. And may ara man nga nanalisari nga defective contracts nga na-discuss sa civil code. And we will try to discuss it also along the way. So, for your objectives, the main objective of this module is for you to define and understand the meaning of contract, for you to understand or identify the essential requisites of a contract, determine the liability of a person for breach of contracts, amo to kagina in case bala nga may mga non-conformity, and understood how contracts are perfected, kag define and identify the various kinds of defective contracts. So for the first topic, Article 1305 of the Civil Code provides a contract is a meeting of minds between two persons whereby one binds himself with respect to the other to give something or to render some service. So in a contract, one or more persons bind himself or themselves with respect to others to fulfill um an obligation, to the fulfillment of something to give, to do, or not to do. So sa contract, there must be at least two persons because it is impossible for one person alone to enter into a contract with himself. And contracts are binding agreements and enforceable through legal proceedings. So, magambal kasi na enforceable through legal proceedings, meaning in case of breach of contract, ang isa ka party may ara siyang remedy for redress, pwede siya kakadto sa court para maka-claim sang damages in case of breach of contract. So protected siya sa legal system of the Philippines. So first natin nga i-tackle is the valid contract. So valid contracts are those nga nagamit siya sang all legal requirements or essential requisites of a contract, and therefore ang implication niya sini is that it is legally binding and enforceable between parties. So the general rule is the right to enter into a contract is one of the liberties or right of a person granted by the Constitution. So any person, for as long as hindi siya limited or wala siya sang mga prohibitions nga ginhatag ang law against sa iya, he or she can enter into a contract by reason of his right granted by the Constitution. So, what are the limitations on contractual stipulations? Ano mga limitation nga hindi ikaw maka-enter into a contract? Number one, law. The law, it is the fundamental requirement that the contract entered into must be in accordance with and not repugnant. So meaning, dapat hindi siya nagalihis or hindi siya nagalapas sa law. And its terms are embodied in every contract. So bali, dapat wala ka nagalapas sa law nga pwede bala ma-apply sa inyo nga contract nga i-enter into. So for example, hindi ka mo ka-enter into a contract sang sale of drugs because selling of drugs is prohibited by law. It is stated in RA 9165. So hindi pwede. And it is one of the limitations on contractual stipulation. Another limitation is police power. So sa police power, kung wala bala may nag-exist nga law or when the law is silent, the will of the parties prevails unless the contract contravenes the limitation of morals, good customs, public order, or public policy. So, diri naman sulod si morals, good customs, public order, and public policy. Kaysa police power, do kumbaga mandate ini siya sa every LG. For example, bala, sa mga LGUs, sa mga elected officials, they can exercise police power para i-stop or i-prohibit those nga contrary to morals, good customs, public order, or public policy. Bisan wala balalagi nga naghahambal nga amo sina. But because of morals or because of good customs kag because of public order, kinadumilian or kinaprohibit ina siya nga i-enter into. Um, Again, contracts binds both contracting parties. A contract is an agreement which gives rise to an obligation. Amo to liga previously nag-discuss kita sa obligations. So, sa obligations one of the sources of obligation is contracts. So, amo na ni siya subong. Hambal taligad sa obligations nga topic nga wala man sang required form for an obligation to be valid, but ang exception niya is that in case the source of obligation is contract, some contracts would require a form for it to be valid and enforceable. And amo na gani, for example, if you enter into a contract of sale of land, you have to comply with the form required, which is dapat ara siya sa public instrument. But other types of contracts nga gina-enter nimo, pwede man siya nga maybe oral or written, or pwede partly oral, partly written. So, amo na siya. And this contract, regardless of its form, for as long as ang law wala nag-require sa form, it binds both parties in order for it to be enforced. And since ginabind niya kamo, bali, hindi ka mo pwede maka-reason out not to comply with the obligation kay bind ka mo or bound ka mo for the fulfillment of that obligation nga enter ninyo. For example, S agreed to sell his car to B for 100,000 pesos. So the contract here is binding upon S and B. And either of them, either S or B, can enforce the contract against the other. So S can deliver the car to B para makasupot siya sa 100,000 pesos, or B himself can ask S to deliver the car para magbayad man siya sa 100 pesos. So they are bound by the contract of sale of car. So since hambal tagani, a contract is a meeting of minds, so because of that, there must be a mutual consent. So maghambal ka nga may meeting of the minds, meaning nag-intindihanay sila. There is mutual consent. Amo na, nag-intindihanay. There is nothing bala nga nag-force sa ila to enter into a contract. Kumbaga, wala man sila ging pilit, kumbaga, sila iya mismo sa ila huna-huna kag sa ila man in their capacity they entered into a contract with each other. So, to reiterate, the compliance of a contract cannot be left to the will of one of the contracting parties, but the law provides that it may be left to the determination of the third person outside of the contract. Pero, ang decision niya shall not be binding until it has been made known to both contracting parties. So, general rule is that hindi pwede nga ang isa lang, for example, si S kag si B, hindi pwede nga si S lang tanan ma-decide. Hindi pwede nga si S lang ma-decide nga ma-deliver siya sa car, tapos si S lang ma-decide kung pila ang presyo. No. Dapat si B nag-agree man or si B man nagbulig man to come up into a decision. Kay balaan, there must be the presence of mutual consent para mahambal mo nga there is a meeting of the mind. Pero in some cases, pwede man nga third person ang ma-decide. Say for example, ginkuha nyo si T abi nag-decide Si T nag-decide nga, okay, S, ang Toyota mo na lang nga Fortuner, ang ibaligya mo kay B ha, and it should be for 500,000 pesos. So, pwede na nga si T ang mag-decide. But, ang requirement nga ma-valid ina is that dapat ging pabalo ni T ina nga decision sa both parties and both parties agreed to it. None of them disputed or protested against the decision of the third person. And in that case, ang result niya, there would be a meeting of the mind and there is also a presence of mutual consent. So, amo na, for example, wala gid bin sila nag-come up into a decision. Wala gid sila nag-intindihanay sa ila decision. Can the parties go to court? Yes. The court here shall decide what is equitable under the circumstances. Pero only in a specific instance nga maka-intra si court. Kay man si court hindi siya pwede makadictate sa parties kung ano ang obligations ng isa kag isa. Si court, up to the extent lang siya sa kung ano ang just, kung ano ang equitable para sa parties. Say for example, may naka-agree na sila sa car, pero wala sila nag-agree sa payment, sa bilis ng car. Say for example, second hand ang car, tapos 2013 pa nga model, tapos ibaligya siya for 1.5 million. So, pwede ka mo kakadto kay court, ka-resort kay court, for court to determine or decide what is equitable under that circumstances because it is considered inofficious. So, amo lang nga instance nga pwede maka-interest si court. Pero kung siling ba lang nga si court kaya maghambal nga, okay, amo ni ho, ang car mo da nga Fortuner, ang Wigo mo na lang da mo na ibaligya sa kay ano for amo ni. No, court cannot do that because ang contract daan, this is the meeting of the minds between two parties. Amo ning si A kay si B abe. And the court cannot intervene that. Kay karon wala na siya sa meeting of the minds. Ma-defeat ang purpose niya. Ma-defeat ang purpose niya into persons nga they can freely enter into a contract. So, as a general rule, a party's rights and obligations derived from a contract are transmissible to the successors, and contracts take effect only between the parties, their assigns, and heirs. So take note of this. Ang ging-enter bala into a contract sa isa ka person, for example, napatay siya, pwede na siya ma-transfer sa iyang mga successors. Or, for example, ging-assign niya na or ging-hatag niya na ang right dira to collect sa lain nga tawo, pwede ina. So, anong example sini? For example, si D may utang kay C sa amount of 10,000 pesos. So, si D kag si C ang parties sa contract. For example, si C napatay. May utang si D kay C pero napatay si C. Is the obligation extinguished tungod napatay si C? No. In this kind of situation, D must pay the heirs of C. Kag kung si C ging assign niya ini or ging habilin niya ini ang iya nga uta ang iya nga surukton sa kay X abe, then si D liable magbayad gihapon kay X. Or amo to, wala abi may assign pero may heirs, si D dapat mabayad siya sa heirs ni C. Ara gihapon standing gihapon ang utang, pwede gihapon masukot sang mga heirs. So what if naman niya balis ka dun ta? Ang napatay iya ang manugbayad. D dies and may heir siya, si H. May ara siyang successor. So then H assumes the obligation of D to C. So meaning ang iyang heir nga si H, siya ang mabayad sang utang ni D kay C. But take note, naman ihambag ko, hindi pwede siya mamana ang utang. Maghambag ko hindi pwede mamana ang utang because ang inugbayad ni H, ang inugbayad sang heir, nga utang ni D sa kay C, kuhaon inaiya sa nabilin nga mga properties or kwarta ni D. Dira na daya kuhaon not on the personal money of the heir. Kuhaon ni na sa estate ni D sang napatay. Okay? And for example, ang estate ni D is only 5,000 pesos. So 5,000 lang ang mabayad niya kay C. 5,000 lang ang mabayad sang heir kay C. Hindi pwede nga manabon si heir. Kaya mula na ang value sang estate nga nabilin ni D. Okay? Pero may exception dira. What if by stipulation naghambal gid sila nga sige ako mapatay kuya sige gihapon mabayad ang for example may exception na da nga hindi siya ma-transfer or hindi siya ma-transmit sa iba. If ang nature sang contract is personal, say for example makanta ka sa wedding tapos napatay ka, hindi mo na pwede mapa-substitute sa heir mo. So meaning hindi siya transmissible, hindi siya pwede ma-transfer. So ma-extinguish lang ang contract because by its nature hindi siya transmissible. Or by stipulation, say for example ging stipulate nga hindi gid pwede ma-transmit, hindi pwede ma-transfer para between us lang ni ang aton utang. So then sorry. So then the parties must respect the stipulation of the contract so hindi siya ma-transfer. Okay? And another is by provision of law. So for example, ma-discuss naman na naton sa partnership nga topic. So sa partnership abe, when a partner dies, automatically nag-extinguish ang partnership. So amo na, kung may mapatay, wala na, extinguish na ang partnership. So amo na siya. So moving forward, what are the cases when strangers or third persons are affected by a contract? Kay di bala ka ginahambal ta, it is between both parties of the contract. Dira lang binding kag enforceable ang contract. So in what cases nga affected ang third person nga hindi man siya dala sa contract? So a third person is one who has not taken part in the contract. So wala siya labot dira. Stranger gid siya sa contract. So as a general rule, si third person wala na siya right and obligation under a contract. Hindi mo na siya mapilit nga magbayad sang utang kay hindi siya dala sa contract. But the exception is number 1, in contracts containing a stipulation in favor of a third person. So kung may contract dira nga in favor siya sa third person, then that third person may be affected by the contract. So ang tawag ta dira is stipulation per autrui, and we will discuss that tapos lang ni naton ihambal ang mga exceptions. So another is in contracts creating real rights, kag in contracts entered into to defraud creditors, and in contracts which have been violated at the inducement of a third person. So para mas klaro, a third person nga stranger sa contract may be affected by the contract. For example, if sa sale balasang land, sa utang sa utang tapos may collateral nga land, parcel of land, nagutang BCA kay B for 1 million peso tapos ging collateral niya ang iya nga hacienda, pero wala kabalo si B nga ang ging collateral nga parcel of land prendado gali ya kay D. So in that case, if hindi makabayad si A sang utang ya kay B nga 1 million, so si B ya forced siya nga i-foreclose adto ang ging collateral. So mahunos ito ang ging collateral nga hacienda. But affected si D. Affected si D bisan third person siya kag wala siya labot sang utang ni A kay B because ang duta nga na or ang hacienda nga na prendado sa iya. So in that case, the third person is affected by a contract. So amo na siya. So another hambal ta kagina, what is stipulation per autrui? Amnesia in a contracts containing a stipulation in favor of a third person. So stipulation per autrui is a stipulation in a contract clearly and deliberately conferring a favor upon a third person who has a right to demand its fulfillment provided he communicates his acceptance to the obligor before its revocation by the obligee or the original parties. So para mas klaro, mahatag kita example. For example, si D may utang kay C for 10,000 pesos, tapos ina payable after 1 year, tapos may 12% interest. So, ging-agrihan nga ang interest ihatag kay T. Si T ang third person. Si T nga na ang third person, indebted or may utang ina siya kay, si T na nga third person, ang may utang na dira sa iya, may utang na sa iya si C. Okay? Klaro? Si D may utang kay C nga 10,000, tapos may interest ina nga 12% per annum. Si T, si C may utang kay T, tapos sa contract ni D kag ni C, ging hambal ni C nga, okay, si T lang makuha sang interest kay may utang ko to sa iya. So in that case, si T is a third person nga affected sang contract ni D kag ni C. So in this case, si T, ang third person, must communicate his acceptance kay D before the revocation of the stipulation by the parties in order that the same will be effective. So dapat mahambal si T nga, okay, batunon ko na siya ang 12%. Kay man, ano man na siya mo, ang floating pa lang na siyang agreement ang tong ihatag bala in favor sa another person or third person, ang interest floating pa na siya. So for it to be valid, dapat ang third person nga to nga wala labot sa contract, dapat i-accept yato. And ang acceptance yato, ihambal yato sa mabayad, sa kay D, sa debtor. So once ma-communicate niya, magwa na siya nga stipulation pour out truly, and hindi na siya pwede ma-revoke. Okay? So, amo na siya. Ano naman yung instances nga third persons are bound by contracts, which means nga which results from creating real rights. So third persons who come into possession of the object of a contract over which there is a real right are bound thereby even if they were not parties to the contract. Amo to kagina ang siling ko nga sa collateral, bound na siya gihapon. Kay man maiguan siya or affected siya gihapon sa paghunos sang hasyenda nga gingamit nga collateral sa isa ka utang nga wala na to siya nadala. Wala to siya labot sa utang ato. But because nga ang collateral nakaprenda sa iya, affected siya. So, what is the liability of a third person responsible for breach of contract? May breach of contract, wala nag-comply ang third person. The law recognizes an instance when a stranger to a contract can be sued for damages for his unwarranted interference with the contract. So meaning, siya diya ang nanggamo sa contract, wala di siya labot, pero nag-interfere siya sa contract. So, pwede siya ma-sue and pwede maka-claim for damages ang aggrieved party. So, amo ni siyang example para mas klaro liwat. S, nag-agree siya to sell ang iya nga parcel of land kay B for 1 million pesos. S sells the land, same land, gimbaligya man gihapon ni S kay C because of inducement of D. Kay gintulod-tulod to siya ni D nga, baligya na lang bala kay C. Baligya mo na kay B, baligya pagi kay C na. So in this case, si B to kagina nga ang tong original nga party nga ginbaligyaan una, pwede yan na masu si D third person. Si D wala to siya nadala sa contract. Si D ang tong nanulsol, pwede yato si D masu for damages. Kay man, wala siya stranger siya sa contract, pero nag-interfere siya sa contract. Paano siya nag-interfere? Ging pilit yato or ging hutik-hutikan niya si S nga ibaligya ang pagid ang same parcel of land sa another person. So in that case, pwede niya masu si D. And may liability kaya si D for interference, for unwarranted interference with an existing contract. So, what are the stages in the life of a contract? So, may mga stages na siya. So, First one, preparation or negotiation. So dira pa lang nada sila dung duga priming dira sila istorya kung ano pwede nila nga i-enter into a contract, ano mga terms and conditions nila. Dira na da sa preparation or negotiation. Naga-ayuay pa na da sila. Next is perfection or birth. So dire, it is when the parties have come to a definite agreement. Nakasettle na sila sa one decision kag one agreement. Tapos na sila nag-ayuay, okay, nag-meet halfway na sila. And last, consummation or termination. So dire sa consummation or termination, it means nga the parties have performed their respective obligations. So ang contract is fully accomplished, executed. So kung na fully accomplished na siya, executed, it also results to extinguishment or termination of that contract. So that's it. Let's have part 2 of this lecture and I will upload it also. So for those nga students or classmates ninyo nga wala pa naka-subscribe or naka-follow sa akong YouTube channel, please tell them para maka makalagas sila sa atong discussion because ma-recorded na lang kitang lecture instead of the live online lecture. So thank you so much. Just wait for the part 2.